1:24 a.m., not all copies had been stamped by the registry. Because of the late hour, the registry did request us to come back at 7 a.m. so that we could verify all the documents that were before them. We were ready to stay there until all the documents were stamped. The assurance that we also received was that because the petition itself had been filed within time, the other documents should have been stamped the same day the main petition was filed.
Let me rephrase this. The Honorable the Chief Justice has said out of the 8 copies that you are supposed to leave with the court, 2 are complete, 6 are not. And I think that's a complaint. Is it not this side of the team? Yes. That certain documents, which they now want us to expunge from the record, were not included in the volumes, whether they were stamped on the 6th or on the 7th. So are you responding to their concern? What to you is the petition? Maybe let's put it that way. What is the petition?
My lady, the petition is a complete set, a complete record of the petition.
Absolutely.
For as long as, yes.
So, there is the petition itself, which is a standalone document.
Yes.
Then there are 8 copies, all right?
Yes.
Inside those copies, certain documents are missing. And it is those missing documents that were not in the original one, unless I have not understood this.
I think there may have been a misunderstanding. When it is said that there are 2 complete records, it means it is 2 complete sets of the petition, volume 1 to volume 16 of what we filed, all of them stamped 6th of November 2017. So it is not that there are missing documents. It is that when the documents were delivered, in the process of verifying each document against the 2 complete volumes that you have, some documents were delivered. In fact, not delivered because we had to go back with them, were brought back the next morning to complete the process of verifying each document against what we have given to the court, the 2 complete volumes.
Ms. Soweto.
Yes, my lord.
We want you to be candid because the information we have from the registrar is that the volumes brought on 7th were not brought along with those brought on the 6th. The registrar is here. You want us to go into that?
My lord, the volumes that were brought on the 7th, because there were some volumes which, even what was given to the court, other than the complete volumes, and I can say it was volume 10A, 12B.
No. Please answer the question.
Yes.
Did you come with everything on 6th?
On the 6th,
Did you come with everything? All the volumes ready there? And the registry got tired of stamping and told you, come tomorrow for stamping. Why didn't you leave them there in the registry so that you just come to the following day for verification and stamping?
My lord, when we came on the 6th, we came with 2 complete sets of the petition, and we kept bringing the others as these ones were being received in sets. It is when...
So you came with 2 complete?
We came with 2 complete sets.
The others, you were coming with them afterwards. That's why they were stamped on 7th.
My lord, not quite, because I was at the registry. We came with all the documents other than some that were not being brought. And some were being brought, yes. As these ones were being stamped, were being allowed to walk in, we carried them. Because it was going to be a long process. Not everything was put in the registry in one place at the same time. That we would admit. But the two complete sets of the petition, which is the basic requirement, was before the court, filed on time.
That's all very well. That's all very well, and we are the first one to acknowledge that.
Yes, my lord.
The question I asked you,
Yes.
did you have all your documents in the registry before midnight on 6th?
No, we did not. We
Yes.
did not have them.
Some you came with the following day.
Some, yes. The only reason they came the following day is because we were stopped from continuing the process once we were there after midnight. Because we had said we are ready to finish the process of having our documents received that same night. The first petition was received at 11:45 p.m. We were there at 9 just to verify volume 1 to volume 16. It took 2 hours. At 11:45 p.m., the court acknowledged that we had filed a full petition, a proper petition, and started looking at now the other documents so that we could provide 8 complete copies and then the other 16 copies.
Olekewa, stand up. You were the one receiving these documents. Yes. Were they all complete? And you were tired of... what is the position?
Only 2 complete sets were complete.
Sorry?
There were 2 sets which were complete.
Yeah.
Then the other ones, they were prepared. They brought the following day.
So those others who were brought the following day?
You are tired. You have to go to camp tomorrow. We did not tell. They left at their own choice.
Oh my Lord, I delivered the second copy myself and went back for the other. What I can say for a fact, and I think this is embarrassing, is that the deputy registrar, who is my friend, was actually not in the court, in the registry at that time when I was there. He may have been at different times, I don't know, but the matter of fact is, as stated by my colleague Julie Soweto, is that we delivered the first set, and it took very long to verify. There are huge bundles, and we kept producing and bringing them. In fact, when I was supposed to come with the last batch in my car, I called Edgar Kavulavu, advocate, and Julie Soweto, who were in the registry, and they said they have told us to come tomorrow, you don't have to come. That is a matter of fact that I can attest to.
Very well, we will decide.
Thank you.
Yes.
My Lord, in any event, the question of the copies being stamped is a procedural technicality. There is no prejudice that is suffered by any of the parties. Particularly when the basic requirement is met that a petition was filed in time. Our duty is to avail to the court sufficient copies of the petition and to avail to the respondents as well sufficient copies of the documents that were lodged as the petition. For this particular argument, we will urge the court to apply Article 159 2D, that justice shall be administered without undue regard to procedural technicalities. This is a procedural technicality. Furthermore, my Lord, the purpose of having the document stamped, each copy, is to ensure that all parties have the same document across board. It is not the stamping that is in question. On the second application, which is the application to strike out certain documents on the basis that they were illegally obtained. We oppose that application. Firstly, my lords, the third respondent cannot be seen to be the one arguing that documents that are not its documents should be struck out. The third respondent has not shown what prejudice they would suffer from those documents, and in what capacity they seek to protect the first and the second respondents with relation to their own documents. If these were the third respondent's documents, then they would have had a basis to make that argument. They do not have that basis. Secondly, my ladies, my lord, the documents that are sought to be struck out are documents that are in the public domain. They are documents that have been circulating widely, have been publicized broadly, some with the implicit approval of the first and the second respondents. Those documents and their contents form a critical part of the grounds in the petition, touching on the independence, the conduct, impartiality and neutrality of how the first and the second respondents conducted itself and their affairs. My Lord, the Council for First and Second Respondents have argued that the documents have been produced selectively. We have made an application. This is actually part of the application for scrutiny for the first and the second respondents to avail all their documents, all the internal memos, all minutes of their meetings, so that we can have a full picture of what was happening. And so the argument that we have produced the documents selectively cannot stand when those are what the petitioners were able to find in the public domain. Thirdly, the considerations of public interest outweigh the third respondent's objection to these documents being considered or being looked at as part and parcel of the factors that the court must make a determination on in the petition. The spirit of Article 35 of the Constitution, Article 10, is one of transparency, sorry, my Lord, the spirit of the Constitution is one of transparency, and Article 35 of the Constitution acknowledges that every citizen has the right of access to information that is held by a public officer or institution. To this extent, the fact that the documents that we already have in our possession are in the public domain, they cannot or should not be removed from the court record and measured against the application to have all other documents produced before this court. Then, my Lord, the public interest outweighs any right or any prejudice that the third respondent claims it might have suffered. Finally, the aim of these proceedings and of the court is to promote the values of the Constitution and the principles to advance the rule of law. If these documents, these memos, the communications between the respondents, what they have publicly put out there, help the court to arrive at a just and fair determination of the matters before the court, then the court must allow them to be part and parcel of the record of the court and of the petition. Much obliged. Unless there are questions for me.
Mr. Veto, you have not addressed Section 27 of the Iebc Act. You have not addressed Article 50, Sub-Article 4, which were raised by the applicants. It's important that you address us on those two provisions.
I beg your pardon, my Lord. I agree. In respect to Article 50, Sub-Article 4 of the Constitution, my Lord, just to read, Article 50 says, evidence that is obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be included if the admission of that evidence would render the trial unfair. Number one, we have not obtained this evidence illegally or in any manner that violates the third respondent's rights. Indeed, that is the argument that I made. The third respondent has not shown how his rights would be violated. These are documents that have been in the public domain. My Lord, and just to comment on the issue of the documents being in the public domain, some of those memos, even after having been publicized widely in the print and electronic media, the first and the second respondents did not come out to object to them. Or in their proceedings. Secondly, on the question as to whether they would render the hearing of this petition unfair, that is a question for the court to consider. You have not been shown how the documents would render the hearing of this petition unfair. And then thirdly, common law principles which our courts apply show that evidence is, even if illegally obtained, which we deny, is admissible if it is shown to be relevant to the matters before the court. On the question of Section 27 of the Iebc Act, the first requirement under Section 27 is that the Commission is under a duty to publish and publicize all important information within its mandate affecting the nation. That is the basic requirement. Subsection 2 addresses where a citizen requires that information, even without the IBC publishing it or publicizing that information. Therefore, my lords, the requirement that subsection 2, the request for the information, whether made or not, does not nullify or change the fact that IBC itself is under a duty to publicize and publish information within its mandate that affects the nation. This again is in keeping with the principle of transparency and openness. The questions before this court are such that it is important to see the transparency and the openness within which the IBC operated.
You should wind up, Miss. Your time has run out.
My Lord, unless there are other questions. And then finally, as I'm reminded by my senior, the IBC has a positive obligation and duty to provide information and access to its documents and to its internal workings. That will be all.
Mr. Ngatia, please, 2 minutes.
I'll be very brief.
Yes.
I think my learned friend took twice as long as we did, but we'll not. I'll be very brief. I start with the second application. This is the documents that we are seeking to be removed. The first question is, what is a petition? The answer is provided in your regulations, the Supreme Court regulations. Definition section defines a petition to include an affidavit accompanying the petition. Rule 6 provides in very clear terms, petitioner has an obligation to file an affidavit at the time of filing the petition. So to the question, what is a petition? The petition includes the affidavit and all the annexures to that affidavit. Second question, was a complete petition filed before the constitutional timeline? Answer is, at the very best, 2 sets were filed before the deadline. The set served on my client, the third respondent, contains documents that were filed after the constitutional deadline. Can we close our eye to it is the third question. The third respondent cannot close his eye to an infringement of a constitutional timeline. It is on that basis that we say the prejudice includes, my lord, the fact that you are now being requested to turn a blind eye to the fact that indeed the petition was filed out of time, and instead of the petitioner filing an affidavit to explain all the matters that my learned friend tried to explain, statements are being now made from the bar about what came at before midnight, what didn't come. All those, my lords, are not sufficient answer for a matter of this gravity. Those answers ought to have been in an affidavit, filed regularly, commissioned, so that there is material upon which this court can exercise a power, assuming the court has a power which could be exercised to enlarge time. As regards the first application regarding internal memo, my lords, we do not subscribe to a contention that internal memos are owned by Iebc, and because they are owned by Iebc, we should not complain. Our complaint is based on section 27, that there is a legal way of seeking documents held by that public body. That legal method includes making a request for that document. It is definitely not an answer to tell us that those internal memos are in a market. We know of no market which has internal memos of Iebc. We do not know that market. And that market has not been defined. And it cannot be a market of illegally obtained evidence because it will still be illegally obtained evidence. The character of being illegally obtained evidence would have escaped if a request had been made and the documents had been provided. My lords, what prejudice do we suffer? The minute we allow, at the commencement of this hearing, evidence illegally obtained to be introduced, will contaminate the process. Will contaminate the process because then that will be a license to litigants to come with illegally obtained evidence or unlawfully obtained evidence and to pendle it before this court. But my concern is perhaps even a notch higher. Are these memos authentic? The only person who can provide that answer is Iebc. Because these are not letters, they are internal memos. Are they authentic? Can I stand before you and assume they are authentic? The answer is, I cannot do so. I cannot assume they are authentic, and it is on that basis, my lords, that we request that all those memos be expunged from the record. This argument would have been totally unnecessary, my lords, and I'm sure you can see the last word I want to say. if a request had been made to IEBC for production of the documents, the most elementary answer would have been that either these memos exist or they do not exist, or for one reason or the other, we cannot disclose them. That was not done. Why was it not done? Is the question, my Lord, that the petitioner cannot answer. Why didn't they do such an elementary process of a letter and say, this is the letter we did, and then in abundant caution, we went to that market, wherever it is, to obtain them. My Lords, on those grounds, I would request you to allow both applications as prayed, because there is no answer to any part of the request that we have made. That's all.
Mr. Ngatia, before you sit down, we have told you we have 2 complete sets.
Yes.
If we agree with your application with regard to the volumes that are filed late, what do we do with the ones which we have?
I go back to the Constitution, my Lord. The Constitution does not allow 2 or 3. It allows all the petition, the complete petition, to be filed within that timeline. And the complete petition would be, if I were to go numerically, the 8 required for the court, and maybe an extra 1 set for the registry, and the other copies for service. Because the set have got to be served must be identical with the set that each judge of this noble court has. So it is not an answer, my Lord, that there could have been partial compliance.
So we strike out even the complete ones that we have, that were filed in time.
Well, the only way I can answer, my Lord, is I can only answer from what I have. And what I have, and I'm an integral party to it, is a petition with documents filed out of time.
No, take my word that we have 2 volumes and we can give them to you to see.
I have no doubt.
Which were filed in time.
I have no doubt, my Lord Chief Justice.
Okay.
I have no doubt. But please see it from my lens, that the petition I have has that constitutional infraction, the infraction of documents filed out of time.
Thank you. Thank you.
Thank you so much, my Lord Chief Justice.
Okay, the next application, is it Soweto or Undubi? The one for scrutiny.
Yeah, she will argue.
Okay.
My Lord, can I address the court with your permission before my learned friend makes that submission?
Yes.
My Lord, and this relates to the time required to argue this matter. My Lord, you will recall that in election petition number 1, when a similar matter came up, and you delivered your ruling on dated 28 August 2017, that ruling was so pivotal that when you look at your judgment of 1st September, that election was nullified because of the scrutiny and the result and the judgment of 28 August. My Lord, from where I sit and where, in light of the fact that ultimately it was the election of my client that was nullified, this application is so pivotal again that we don't think, with tremendous respect, that 10 minutes is enough, especially in light of its consequences. My Lord, I petition your good office and the court that we be given adequate time. And my Lord, I don't read how many paragraphs in the final judgment you refer to this scrutiny. We require adequate time, my Lord, to argue this scrutiny.
What do you consider as adequate time?
Yes, my Lord, I don't want to sound out. 30 minutes will be fine. 30 minutes.
30 minutes for each?
Yes, yes, that. I don't know how long they will require. They may require less than myself. But for the third respondent, 30 minutes, my Lord.
Mr. Ahmed Nasir and Mr. Ndubi.